We will speak today about the role of the judiciary and the courts. And the courts are very important to realizing not just the protection of the environment today, but the rights of future generations. As you know, there's a maxim in the law that says, if there is no remedy, there is no right. The theoretical right that cannot be enforced or observed is still a good idea, but it doesn't relieve the problem that it's supposed to address. So we have created over the last hundreds of years the judicial branch of the government. And the judiciary is not just to enforce laws in a positivist way with criminal law or sanctions, but it is also to realize the protection of the individual and the ensuring that individuals' rights and privileges are duly observed by both government and others who could interfere with those rights. So when environmental law began to come into existence, the first places in which people brought their claims were to the courts. They tried to go to the legislature, they tried to go to diplomats, but the environmentalists found that the old regime, the ancien regime, continued in these areas, and they weren't ready to quite quickly observe that there might be rights in nature or that there might be rights against pollution. Pollution was part of doing business. It was part of the economic paradigm. So one of the first cases that recognized the rights of future generations and the right to the environment is the famous Oposa miners case. It's the case of Oposa versus Factoran, in which Tony Oposa, who is the holder of the Normandy Chair for Peace, 33 years ago, more than that, realized that the government had given so many concessions away to cut down the timber in the Republic of the Philippines, cut down all the trees, that if all the concessions were implemented, there would be no more forests ever, and his small children and the children of his friends would never see a forest again. So he brought this case in the name of the children. They are the ones who had the virtual standing to speak for the future generations. And he presented to the court a claim that these children had a right under the Philippine Constitution to a good environment, and that included being able to enjoy a forest and all of the ecosystem benefits and spiritual benefits that come from a forest. And naturally, the first judge looked at this and said, "This is ridiculous. I don't see anything in the Constitution. I'm going to reject your case." Well, Tony is a very persistent and insightful person. So he knew he had to keep appealing until he got to the Supreme Court, the highest court in the Philippines. And there they are not so tied to the economic forces of the day. They have more perspective. They're the more senior judges. But his case was still a very strange case. It had never been had before. And so the judges assigned it to a young judge. They said, well, this is not going to be worth our time. Let's give it to a new judge on the bench and let him figure out what to do with it. And that individual was an also extraordinary individual, Justice Davide. He received the case and he did his research and he looked at the Constitution. And in the Bill of Rights, of course, there is not a right to the environment as such. But in the Constitution itself, there is a statement of the duties of the government. And the government has an obligation to ensure that the well-being of the people and the natural resources are duly maintained. It could be viewed maybe as an early statement that government has a duty to maintain sustainability, sustainable development. And he read into this part of the Constitution the fact that there is a right to the environment that did not need to be explicitly expressed, because as he put it in his decision, the right to live the right to survive, the right to help your children survive is an inherent right in every human being. We have this privilege to protect the environment for ourselves, for our children, for our grandchildren, for all time. And he said this right, this basic human right goes all the way back in time to the beginning of human society. It's an ancient right inherent in us all. Now notice, the world has come to accept the legitimacy of this argument. Just last summer, the General Assembly of the United Nations adopted Resolution A/76/300, recognizing the human right to the environment. This UN recognition is very much the same as the recognition of Justice Hilario Davide Jr. Justice Davide went on to be, in fact, the ambassador of the Philippines to the United Nations in a later period in his life when he was no longer Chief Justice of the Philippine Supreme Court. But Justice Davide, in that decision, was like a pathfinder. He showed the pathway for other courts to do the same thing. And so the Supreme Court of India interpreted the right to the environment. The Supreme Court of Pakistan did the same. Nepal, in other parts of the world where the Constitution provides for the right to the environment, courts activated that right. They said we must take action when it's brought before us. And so the role of the judiciary has always been important in implementing the right to the environment. And this applies, of course, to all environmental laws. Now, the ability of an individual to go to court depends upon the availability of lawyers to represent them in the court, the availability of judges who understand environmental law. And so in the history of developing a stronger judiciary as a place for bringing environmental rights to life, for giving remedies to the environmental rights, the International Union for the Conservation of Nature and the UN Environment Program began an international effort to strengthen the role of the courts in environmental law. This was a really quite remarkable achievement. First, we held hearings or conferences to do needs assessment in all regions of the world. The first one was held in Sri Lanka. There was another one held in the Philippines for the ASEAN area, the Association of Southeast Asian Nations regions. There was one in London for Western Europe, one in Lviv, a city in Ukraine, for Eastern Europe and the former area of the Soviet Union. We held one in South Korea for North Asia, and South America, and in the Caribbean also. So all of these needs assessments showed that the courts were frankly underfunded. The legislature and the executive branch do not really give the resources to the courts that are required for their work. So we began to say, how can we provide capacity building? How can we strengthen the knowledge of the courts? And a number of programs were conducted along the lines of continuing judicial education. Judges had never studied environmental law when they were in their universities because the field did not exist. And so we began to acquaint the judges with law by holding seminars, advanced workshops on what was this field, the strange field of environmental law that was coming into their courts. And eventually, both UNEP and IUCN decided we needed an institutionalized basis for this. The chairman of the World Commission on Environmental Law, Justice Antonio Herman Benjamin of the High Court of Brazil, was the chairman of the IUCN Commission on Environmental Law, and he began a negotiation with courts around the world, facilitated by the UN Environment Program and IUCN, but really run by and for the judges. And the judges had already been organizing. We have in Europe the European Forum of Judges on the Environment. And Luc Lavreyson, Justice Lavreyson, is of the Constitutional Court of Belgium. He's also a professor of environmental law. So he is the current chairman of the European Forum of Judges on the Environment. The International Association of Judges came on board. It's not an environmental group, but it works with judges in capacity building. And so meetings were held in Brazil and other parts of the world, in Asia. The Asian Development Bank decided to open a program for all of the countries in Asia on the capacity of courts to understand environmental remedies and how cases should be handled when they come to court. So they held symposia and workshops just of judges to compare their experience. So we now have a whole period of comparative environmental judicial practice that has emerged around the world. And out of that came the proposal from IUCN with the support of UNEP to create a global judicial institute on the environment. The Global Judicial Institute has a small secretariat to facilitate its website and things given by UNEP, but it is organized by judges and for judges. It has a cooperative program with universities, which is just beginning, but it is not run by the executive branch. It is not run by the foreign ministries. It's not run by the UN. It's run by judges. Judges are autonomous. They have to have the independence to make their own decisions. Some judicial systems are in socialist states and now also in the post-socialist Russian Federation are what is known as instructed judiciaries, where they don't really have the independence to make their own decisions as individual judges. There is an intermediate level of instruction, which you see in China. The Chinese Communist Party has decided that the courts are very important for the protection of the environment. Without the courts, the other parts of the state will not follow the environmental rule of law. They tend to follow economic advance or sometimes corruption. And so the party decided that we had to strengthen the courts in China, and they created, the People's Congress created a large system of environmental courts. So China has the largest body of environmental courts in the world, and it is giving remedies. It's giving remedies to individuals who are polluted, to NGOs, non-governmental organizations in China that exist under the party, that are a different entity than those that are polluting. Many of the problems of a socialist state is that the executive branch is also, the polluting branch. So some of these state enterprises say, why should we follow the rule of the Environmental Protection Ministry? It's just another ministry, and we're a ministry too, and we're more powerful, and we make more money for you than the government. So stop having the environment officials interfere in our work. And that political and legal argument prevails in many places until the judicial branch steps in. And they can't control the judiciary in the same way. So China has instructed the judiciary to be independent and enforce the environmental laws across all parts of the economy. And that is now beginning. So we can go to examples in the Supreme Court of Mexico. We could go to examples in other European courts. And in Africa, some marvelous regional court decisions. There's a very courageous decision stopping a highway going through a series of national and even international protected areas in Tanzania, for instance, by the Regional Court of Justice there. We have decisions in the European Court of Human Rights. And so we're finding a judicial willingness to address the right to the environment. Now, when the right to the environment was accepted by the UN, the question comes up, well, what about, who has that right? Is it only the present generation? No, I think the panels that you've had at this summer school show you that intergenerational interests are real, they are alive. They may not be in the room with us today, but we are pregnant with their presence. We know they are here. We know we will be gone one day and they will be us. And therefore, the great challenge that we have in the courts today is to give voice to the future generations through the right to the environment, to articulate how we must, as the Brundtland Commission said in the study, Our Common Future, how we must be sustainable, how we must only use what we need today in a way that ensures that those who come tomorrow will have what they need as well. And of course, as you know right now, we are over-consuming. We are not following this rule. And so, frankly, we're a little bit like those state enterprises in China that pollute because they know they can and they get rich doing so. But we need to have a way to stop our dysfunctional behavior. And the remedy will be in 1,000 judicial decisions in many court cases around the world in which the judges tell us to stop misbehaving. It won't happen in one big case. It will happen in many small instances that accumulate. Just as the harm to the earth is accumulating incrementally, so must the remedy accumulate incrementally. And we will find ways to protect the environment for ourselves and future generations. Now, the Global Judicial Institute is still very young. We have the support in Europe of the European Bank for Reconstruction and Development, which, like the Asian Development Bank, is holding programs to strengthen the courts and give them the capacity for judicial independence, to stop corruption in places where the courts are influenced by corruption. And so this campaign continues. In states like New York, where I teach, we have a Judicial Institute of the state of New York, which is also continuing to strengthen the role of the courts and take on environmental law. And as of last November, the state of New York, the people voted in a special election 2-1 to amend the state's Bill of Rights to provide the right to the environment in the state of New York. This is a very powerful decision. It joins the state of Hawaii and Montana, Pennsylvania. These are the other states that have the right to the environment. So even if it's not in the federal US Constitution, it is coming up through the states. And a very dynamic and advocate, Maya Van Rossum, has just launched a campaign for the Green Amendment, as she calls it, to provide the right to the environment in every state throughout the United States, state by state. So we don't have to wait for Congress. We can do it that way, but we can also do it through the courts. And that same problem is going to be arising in every country in the world. So the Global Judicial Institute does not have universal participation yet of judges. Judges are not given any money to travel. They only live in their courtrooms. So we have to build up the capacity to use the internet to bring the world to everyone's courtroom and to provide continuing judicial education where the judges are, and then get their contributions. They have a website in which all of the decisions on the environment are made available to the judges through a private server. So judges can have their own private library, if you will, of judicial cases and learn from each other without influence from outside. The influence can come from either environmentalists or it can come from anti-environmentalists, but that's not what we want. We want an independent body of knowledge that the judges can draw upon in an independent way to arrive at their remedies. So that's a survey of the horizon. I'm sorry Justice Benjamin cannot be with you to share his perspective, but the High Court is a very demanding place in Brazil. I was privileged to participate with him in these meetings over the last 10 years. And the prior 10 years before that, I worked with IUCN and UNEP. In fact, it was in 2002 at the World Summit on Sustainable Development in Johannesburg, South Africa, that the first meeting of all of the Supreme Courts of the world to address the question of environment was presented by UNEP, and along with Dr. Parvez Hassan, who won the case to establish the right to the environment in Pakistan. He and I represented IUCN at that meeting. And so we've come a long way since that very initial meeting in 2002. It's now 2022. 2 decades later, we have a decision of the UN on the right to the environment. We have a wonderful statement by the UN Environment Program on the environmental rule of law. You should study the reports of UNEP on the environmental rule of law and see how UNEP is now reporting on the role that courts play in ensuring the right to the environment. I would be happy to respond to any questions if there are some. I know it's a little difficult by remote, but it's a privilege to have shared with you the progress, I would say, that we are making in strengthening the role of the judiciary to protect the environment. Merci,